Hi, everybody. Thank you for joining us today. I'm just going to give it a couple of seconds. I see a few other participants are joining us. As you can see, I hope you're in the right place. You're at the Advanced Care Planning Know Your Rights webinar. My name is Karen Dietrich, and I am the Director of Advanced Care Planning at the Canadian Hospice Palliative Care Association. I am joining this webinar from the unceded territory of the Algonquin Anishinaabe people who have lived on this territory for millennia. Their culture and presence have nurtured and continue to nurture this land, and I'm grateful to have the opportunity to be present on this territory. I do invite others, if you so wish, to share where you're joining us from in the chat, whether that be your location, your organization, the room in your house. If you're driving, please don't type. But thank you, everybody, for taking the time to join us here today. This is the second webinar of a two-part series stemming from the results of the 2021 Advanced Care Planning National Poll released in August of this year. The poll asked about people's attitudes and behaviors towards planning for their future health and personal care and compared itself to findings from 2019. So this webinar was created, this webinar series was created in response to findings from that poll that indicated some confusion around what is advanced care planning. So we wanted to kind of demystify that a little bit, as well as some of the legal elements around it. So the first webinar reviewed the basics of advanced care planning, and a recording of that webinar can be accessed from the resources section of the advancedcareplanning.ca website under videos. Similarly, a recording of this webinar will be made available on the website as well for those who are watching this as a recording or who were not able to join us today. If you're interested in those poll results, you can also find more information about them. There is a summary report, there is an infographic, a few articles around advanced care planning from different perspectives on our website, again, under resources. Before we begin, I do want to be clear that today's webinar is for information purposes only. Speakers are not here to provide legal advice or answer any specific legal questions pertaining to individual circumstances. So what is advanced care planning? For those of you who were not able to join the first part of the webinar, advanced care planning really, or ACP, you'll often hear a few of us say, ACP really is a process of reflection and communication. It's a chance for you to reflect on your values and your wishes, and to let people know what kind of health or personal care you would want if you were unable to speak for yourself. So the whole idea is to speak with those who are closest to you, who will be identified as your substitute decision makers if ever you find yourself in a situation where you can no longer speak for yourself. While the formal documentation and legislation around advanced care planning may differ across Canada, the core of advanced care planning remains the same. Thinking about what's important to you and speaking with those who are important to you about your wishes and preferences. You don't have to go into all sorts of different details. The more people understand about what you consider important for your quality of life, your values, that's really the heart of advanced care planning, no matter where you're joining from. So we're actually going to do a little poll because we're curious to know, I'm curious to know, our speakers are curious to know, how many participants on this webinar have spoken to anyone about any of their future healthcare wishes? So perfect, thank you, Michael. So you'll see there, hopefully you can see the poll questions. So you'll see a few different choices. If you can take a moment to let us know, and you can choose more than one. So this actually is similar to one of the questions. Actually, it's not quite exactly the same, but some of the questions that were on that 2021 national poll that I responded earlier, or that I mentioned earlier. So we'll just give folks a few minutes to answer that. And then I think, Michael, you can kind of see the general response rate. So when you think we've gotten most of the responses from people, if you can share those results, that would be perfect. All right, thank you, Michael. So family, most popular, followed by friends, doctor, 20% lawyer. So the poll was 10% lawyer. So we have a bit of a higher group here. This is similar to the national poll results. So family and friends were by far those that people have spoken to the most. Doctor is much higher than what we saw in the poll. Only 7% of respondents had identified speaking with any healthcare professional. And some folks were prompted actually to consider advanced care planning based on their discussions with lawyers. So interesting to kind of see the mix that's here. We have one financial planner, great. I know we don't have a place to put responses for other, but please feel free to put that in the chat because we're always curious to know who you're having those conversations with. And thank you for those who have not discussed it with anyone for joining us here today, because I think this is all part of the learning journey that we are on. Let me just close that. And just before we move on, advanced care planning in Canada, just so that folks are aware, is a national collaborative project that works with advanced care planning champions across the country. So these are leaders in health authorities, legal firms, government departments, a variety of champions for advanced care planning in their respective jurisdictions, so that we can all share and learn from one another around what's working well, tools, information, gaps, and we work together to try to increase awareness about advanced care planning amongst Canadians, healthcare practitioners, legal professionals, so anyone really that would be touched around our life planning model, which you're going to hear more about in just a second. If you would like to learn more about advanced care planning in your province or territory, you can also visit advancedcareplanning.ca, and in the top navigation menu, there is something called ACP across Canada. So if you are curious about who are the leaders or the authorities in your communities, please do go there. And it's a great resource for local information. So what will we cover today? Today, we're going to take a closer look at the life planning model and how it fits into advanced care planning. And we'll also learn more about advanced care planning from a legal perspective. Much of the content that you'll see on this webinar was based on a recently updated resource called the Living Well, Planning Well, an advanced care planning resource for accessing your rights. So the updates recently, if you've heard of this before, if you accessed that tool when it was originally released in 2019, it looks very similar. It's just that there was a few legislative changes that took place recently, so we wanted to make sure that the resource was up to date. Again, this can be found in the resource section of advancedcareplanning.ca. I would like to take an opportunity to thank the legal professionals from Harper Gray, McInnes Cooper, Miller Thompson, and Torkin Maine for the development and the recent update of the Living Well, Planning Well resources. There is one for the general public. There's also one developed for lawyers so that everybody is on the same page and getting consistent messaging. I am thankful to be joined by some of those professionals here today, so that you're not listening to me speak that much today, but actually we're going to be hearing from Sandy Abley and Daniel Stober. So before I turn it over, I'll just tell you a little bit about our speakers today so that you know who is speaking to you. So Sandy practiced in the areas of estate and tax law for 15 years. She is a certified financial planner and a trust and estate practitioner. She also holds a joint degree in business and psychology. Sandy helps individuals and couples navigate the worlds of investment, tax, and finances. She also works with nonprofit organizations, companies, and other professionals as a consultant on their projects, toolkits, and curriculums. She will be kicking us off today with a deep dive into the life planning model, which you may have seen in that resource or across multiple resources. It has been a model that's been widely adopted across advanced care planning Canada and amongst our partners. So we're very thankful to Sandy for her work in developing that model. After Sandy, we will hear from Daniel Stober, who was instrumental in the recent review of that Living Well, Planning Well resource. Daniel is an associate in the Wills Trust and Estates Group of Torkin Maines. His practice is focused on estate planning and estate administration. Daniel advises clients on the preparation of new wills powers of attorney and trusts. I'm sure you'll hear a little bit more about some of that today. He also advises estate trustees on all aspects of the estate administration process. And we are very thankful to have Daniel here today because, as many of our respondents in the national poll indicated, sometimes dealing with legal matters can be intimidating, sound technical and jargony and overwhelming. And Daniel's got a way of making it seem less overwhelming. So thank you both so much for being here today. Before I hand it over, just for a little bit of flow and instructions. So each presenter will be speaking for about 10 to 15 minutes. And then after both presenters have gone, we will take time for questions and answers. Please pose your questions in the Q&A function of the Zoom webinar platform. If you pose your question in the chat, that's okay. We'll try to keep track of it there, but sometimes the chat is filled with a whole bunch of other comments or technical questions. So to make sure that your question is addressed, please put it in the Q&A section. If you prefer to ask your question verbally, you can raise your hand and we will do our best to unmute you. We tested it. I think we still know how to do it, but that Q&A feature is probably the best. So I think that is all the housekeeping for now. And with that, I will turn it over to Sandy.
Thank you very much, Karen. And there I see that my life planning model is up. There's 3 circles, and you'll also see that there are overlapping sections of it. So I'll just do a quick overview. You know, when people talk about estate planning, usually people think, oh, I've got to do a will. And sometimes it's more than that. Parents sometimes write a letter of wishes. You know, if both parents die in a common accident, I've done this where I've written a letter of wishes of how I would like my daughter to be raised and how important education is, and, you know, for her guardians not to be cheap with her. So there are letters that you can write. They're not legally binding, but I think there is, it's nice for my daughter to read if she ever has to read it. And also it gives some instructions to her trustees and to her guardians. Trusts can be created in your will, and it can also be created during your lifetime. Typically, trusts that are created in your will have to do with minor children and when you would like them to inherit. If you happen to die early, sometimes trusts are created because there are people who are dependent on you and you want them protected. Life insurance is part of your estate planning. If you have a business, you own a corporation, you have to sort of give some thought to what happens if you die unexpectedly. How will the business continue without you? And then other trusts, which I've mentioned before, that you can create during your lifetime so that certain assets don't fall under your will. And we won't get into that today. They're a bit more complex. So when we talk about estate planning, and I'm sure Daniel will talk about this more, it's not just about your will. All of these pieces and tools are part of your estate planning. And then you'll see between estate and financial planning, you've got tax planning and gifting. And I put those there because you can gift and do tax planning during your lifetime or create it in your estate. You know, a part of estate planning is also to reduce taxes on death for some people. And then the middle part is what I call financial, but really it's everything you have to do as an adult. And I think this is a great model to give to your kids as they graduate from university or from high school, because these are all the things that they're going to be responsible for. Managing their cash flow, saving for their children's education, investing. Risk management is basically insurance, right? Like you live, so you need insurance for your car, for when you travel, fire insurance for your house. So all of that is under risk management. Certain people may want to have a marriage or cohabitation agreement before they get married or move in together with someone to protect their finances. So that's under financial. And then under advanced care planning and financial, you'll see I've got enduring power of attorney up there. And sometimes people confuse a will with a power of attorney. So a will only operates from the moment of death. And a power of attorney only operates while you're alive. And it's basically of no value once you die. An enduring power of attorney is one that continues to be valid even if you're unable to speak for yourself. So, for whatever reason, you are in, let's say, the hospital and you can't speak, you can't communicate in any way, you can't blink. Somebody who is your attorney named under this document will be able to file your tax returns for you, will be able to pay your property taxes, pay your bills, make financial decisions for you. So that document has to endure your incapacity. You're still alive, but you're incapable. So that's the difference between those two documents. And that helps you with your finances, but it also helps you with your advanced care plan. Some people in the audience may have experienced having to need this document because they're taking care of their parent. And then what goes along with your power of attorney is another document, and it has different names across Canada. In British Columbia, it's called a Representation Agreement for Healthcare. I believe in Ontario, it's called a power of attorney for personal care. And this is where you appoint a substitute decision maker to make decisions with respect to your health care and your personal care decisions. So sometimes people think this is a sort of like an all or nothing person. You know, they say, yes, put me on a ventilator, or no. But this person can make decisions about your diet, about where you live, who brushes your hair. So this person makes a lot of important decisions about your comfort and your safety. And then, you know, thinking about your long-term care options, where you want to live long-term. Many people want to live from home, so you need to think about how to make that happen safely. And then, you know, during end of life, how comfortable you would like to be. And so depending on where you are in your life, you know, if you're starting out and you've had your first baby, you might be more focused on managing debt and maybe writing your first will and appointing a guardian for your child. And maybe later in life, you have some health issues and you're much more focused on getting a medical order together or appointing somebody to take care of you and making decisions for you when you're unable to. So I think the whole life planning model is something that all of us can refer to, whether we're, you know, 20 and starting out, or whether we're, you know, 98 and want to make sure that we're comfortable and safe, and what we value and what we want for ourselves is going to be respected by our caregivers, our doctors, and the people that we love.
Thanks, Sandy. And I think in our conversations prior to this, Sandy used a fun word that I've used with my children called adulting, right? So this is really the life planning model. I remember conversations with my father when I was 16, 17, and he was trying to teach me about retirement savings. When I was 16 and 17, I wasn't really interested in retirement savings. But I do understand the math, and I do understand the importance of planning early and what he was trying to teach me. So I think too, in looking at all of this, I think the idea, I mean, Sandy, I guess the question for you is, you know, if people are looking at this and they're going, holy smokes, that's a lot of stuff to do. How do I know where to start? Do I have to do it all? Like, can one help me? Where do I go? How much money is this all going to cost me? I mean, I love the life planning model, and a lot of the champions that I mentioned that we work with, this has really resonated with those who have been working in advanced care planning for a long time. You work with a lot of different clients and organizations and individuals. How does this model resonate, and what are your kind of thoughts if people go, ooh, this is a lot to do?
Right. So I show this model to people who are thinking of doing a financial plan, and I also show it to clients who are thinking of doing an estate plan. And I always stress that there are just certain portions of the life planning model that will be more important to you depending on where you are in your life. So when you're, 29 and getting married and thinking of your first baby, you're not thinking about palliative care options, right? You're thinking about a will and maybe buying insurance, and paying down debt. So the nice thing about the model is no matter what age you are, it applies to you. And some will apply more to you than others. Eventually, hopefully, you will have checked off the list, everything off the list, by end of life, because we all want to be comfortable and safe right until the end and without pain. I think definitely it's a checklist, but you don't have to check everything off the list right away. Some people are never going to do a cohabitation agreement or marriage agreement, right? But if you know you're going to be inheriting $10 million, that's something that you might want to think about. And not everyone is going to need a trust either. So I've just got every single scenario here in case it's something you need to turn your mind to, something maybe you haven't thought of before. There are probably some business owners listening to this webinar, and maybe they haven't really turned their mind to, what happens if I get ill and I can't operate my business for 6 months. We've heard some sad stories about, very young people in their 30s and 40s owning businesses and, having COVID and in the hospital. Did they think about something like disability insurance to pay their day-to-day expenses or their business expenses? And so that's why it's all encompassing. My mom, I think we spoke about this. I took her recently to tour an assisted care facility, and she didn't want to go, but she sort of wanted to go on a field trip, so she agreed to go. And I don't think she's ready, and in the next year or even 2 years to go into assisted living. She's quite independent, but right now she's alert. She's capable, she has a sense of humor. And so this is a good time to take her, right? A bad time to take her would be when she's not capable and when she's not thinking clearly because she's ill. So this way she might have a year or two to digest and think about the idea. So that's what I love about planning is you can plan, you can think about it, but you don't have to do it right away. You can be prepared for when the time comes.
Perfect. Thank you, Sandy. And I think that speaks so precisely to the whole premise of advanced care planning, right? It's planning for when we might not be able to speak for ourselves. And that could happen suddenly and unexpectedly, and it doesn't need to happen all at the same time. So thank you very much for that.
You're welcome.
I am going to now stop sharing my screen. So pardon the abrupt adjustment, and I'm not even quite sure what you're going to see. There we go. And I will now invite Daniel to share his screen for his portion of the presentation.
Thanks, Karen. I hope that this works. There we go. So thanks, Karen, for the introduction earlier. Again, my name is Daniel Stober. I'm an associate lawyer at Tork & Mains, a law firm in Toronto. My practice is focused on estate planning and estate administration. And as part of my estate planning practice, I advise clients on and prepare powers of attorney for personal care or advanced care planning documents in Ontario. Obviously, as a lawyer, I just want to reiterate the disclaimer that Karen gave at the beginning, which is that my presentation is for general information purposes only. Just as a sort of an introduction, oops, sorry about that. Many Canadians think that advanced care planning is more complicated than it really is. And this comes out of the poll that Karen mentioned. And I think the latest poll number is that 88% of Canadians think it's important to talk with loved ones about advanced care planning, but only about 36% have done so. And one of the main barriers that poll found that prevents Canadians from engaging in advanced care planning is the belief that they can't afford a lawyer or professional to help them. And what I'd like to do in my segment is talk about the value and the benefits that a lawyer can provide to the process, and sort of go over, the more legal aspects of advanced care planning. I'll just note that my presentation and my comments are really focused on Ontario law, which is the jurisdiction that I practice in and that I'm familiar with. Each jurisdiction in Canada has its own legislation that deals with advanced care planning and substitute decision making. There is a lot of overlap and a lot of similarities between provinces. But it is really important that you take the time to speak with a legal professional in your province where you reside, and to get advice that's specific to your province. So what is the role of a legal professional in advanced care planning? Most obviously, lawyers can prepare legal documents that permit substitute decision makers to act on your behalf. So again, in Ontario, that document is called a power of attorney for personal care. Sandy mentioned that in BC, it's called a representation agreement for healthcare. Other provinces have different names for that legal document. But the general gist of it is that it's a legal document that permits someone who you name to make decisions on your behalf with respect to your personal care if you are not capable of making those decisions yourself. Lawyers can document your wishes for treatment, residency, so where you want to live, and other personal care matters. And those wishes can be included in the legal document itself, but they don't necessarily have to be. Lawyers can help you talk through and decide who should be appointed as your substitute decision maker. So lawyers can, bring to the table their experience in dealing with these matters and, help you come to that decision about who should be appointed. And a lot of times it's talking through the family dynamics, so if the client has multiple children, talking through whether they should be appointed together, and if they are, will they be able to work together to make decisions in an effective manner, or should it really only be one of the children that's appointed? So really working through those dynamics, talking through that is something that lawyers can help with, and that we're generally experienced with. Lawyers can help you determine whether an advanced care planning document that's prepared outside of your jurisdiction is valid. So perhaps you've recently moved from one province to another, or from outside of Canada to Canada, and you have a healthcare document that was prepared in your former jurisdiction of residence. A lawyer can help you determine whether that document is still valid where you live now, or whether a new document should be prepared. Lawyers can also help sort out healthcare decision making when you spend your time in different places. So maybe you have a winter residence in Florida or in Arizona or somewhere else where you spend some time of the year. It may make sense to have a separate healthcare advanced care planning document in that jurisdiction. If you spend 4 months of the year in Florida and something were to happen to you while you're in Florida, it can make the process much more straightforward if healthcare workers in Florida and people you're dealing with there are presented with a document that is prepared in accordance with Florida law and that they're familiar with, as opposed to them being presented with a Canadian document and trying to sort out whether it's valid. So that lawyers can help with those interjurisdictional aspects as well. The most important thing to note is that conversations regarding advanced care planning and your wishes can and should happen without lawyers' involvement. And I think this is reflected by the poll that Karen took earlier, which showed that I think only around 20% of the participants on this seminar have spoken with their lawyer about advanced care planning. The most important conversations really do happen with your family, your friends, the people who you've named as your substitute decision makers. So navigating the legal framework of advanced care planning, and again, my comments will focus on Ontario, which is where I'm residing and where a number of our participants are residing. There are two main pieces of legislation in Ontario that relate to advanced care planning. One is the Healthcare Consent Act, and the other is called the Substitute Decisions Act. The Healthcare Consent Act governs consent to treatments, and treatments are defined in that act as anything that's done for a therapeutic, preventative, palliative, diagnostic, cosmetic, or other health-related purpose, and includes a course of treatment, plan of treatment, or community treatment plan. There are certain exclusions to what is considered a treatment. For example, a healthcare professional taking a health history is not considered to be a treatment. Treatments, as defined in the Healthcare Consent Act, require consent. And the consent either has to come from the person themselves, if they're capable of providing consent, or if not, from the person's substitute decision maker. And within the Healthcare Consent Act, there's a hierarchy of persons who can give consent for a person who's incapable with respect to a treatment. So top of the list is the court-appointed guardian of the person for that person. So if that incapable person has a court-appointed guardian, then that guardian has first priority to give consent. If there's no guardian of the person, then the person's attorney for personal care. And an attorney for personal care is the person named in a power of attorney for personal care as substitute decision maker. Number 3 is a representative appointed by the Capacity and Consent Board. Number 4 is a spouse or partner. So if you don't have capacity to give consent and you don't have anyone who fits into the first 3 categories, then your spouse or partner can provide consent on your behalf. And if you don't have a spouse or partner, or if they're not available or they're not capable themselves to provide consent, then a child or parent, then a sibling, and then any other relative. So this hierarchy is, very prescriptive, and the issue that many people face is that they want to name someone to be their substitute decision maker that's not in accordance with the hierarchy. So you might want to have your spouse first as your substitute decision maker, which is, they're on the hierarchy. But then you might not want your children to be substitute decision makers, either because they're not of the age of majority, or even if they are of the age of majority, maybe they're still in school, they're not mature enough, or maybe you just want someone else who you think would more closely follow your wishes. And that's really where the legal document itself, the power of attorney for personal care or advanced, whatever it's called in your jurisdiction, that's where that document comes in to allow you to name the person or persons you would want to make decisions on your behalf. So switching gears to the Substitute Decisions Act, and just going over some terminology that's in that act. A power of attorney for personal care, as I've mentioned, is the document that allows you to appoint a substitute decision maker. The attorney for personal care is that substitute decision maker named in the power of attorney. The use of the word attorney is a little bit can be misleading. It's not attorney as in lawyer, which is really more of an American term. It's the attorney is the person named under the power of attorney for personal care who's acting. The grantor is the person who gave the power of attorney for personal care. And personal care, or sort of the scope of things that can fall within the power of attorney for personal care, includes shelter and living arrangements. So, the attorney for personal care can decide where you're going to live, hygiene, nutrition, clothing, safety, and again, decisions to which the Healthcare Consent Act applies, which is really providing consent to treatments. So again, the Substitute Decision Act provides for the creation of a power of attorney for personal care, which authorizes a person or persons who are named as attorneys to make on the grantor's behalf decisions regarding the grantor's personal care. A power of attorney for personal care must be in writing, must be dated, and must be signed by the grantor, but it doesn't have to be in a particular form. And really, the value that lawyers can provide in the advanced care planning process is ensuring that your power of attorney for personal care, that your advanced care planning document meets the requirements to be valid in your jurisdiction. These requirements vary from province to province, but I think that the requirement that it be in writing, dated, and signed, and in most provinces witnessed as well, I think that's pretty consistent across the provinces. And the lawyer can ensure that the document is in the proper form, that it meets the requirements, that is properly witnessed to ensure that it's valid. Because, going to the efforts to document your wishes, prepare a power of attorney, but then to have it not be compliant with the legislation would really, not be reflective of your wishes. To create a power of attorney for personal care, you have to be 16 years or older. You have to understand whether the proposed attorney has a genuine concern for your welfare, and you have to understand that the proposed attorney may need to make decisions for you. So those are the criteria to be capable to give a power of attorney for personal care. And the criteria, the threshold to create a power of attorney for personal care is it's not that high. And if you've got someone in your life where you're not sure if they're capable of giving a power of attorney for personal care, there are professional assessors who are qualified to assess a person to determine whether they meet the criteria to give a power of attorney for personal care. As I mentioned earlier, one of the benefits that a lawyer can bring to the process of advanced care planning is deciding who you are going to name as your substitute decision maker or your attorney for personal care. And there's a lot of flexibility within a power of attorney for personal care. You can appoint one attorney or you can appoint multiple. If multiple attorneys are appointed, they're presumed to act jointly, meaning they must act together unless the power of attorney for personal care states otherwise. We have clients sometimes who want to name two people, but have them able to act jointly and severally, meaning that either one can make decisions without the involvement of the other. And that's usually done for flexibility. In case one of the attorneys is traveling or isn't available, they want to make sure that decisions can be made in an emergency. Sometimes we have 3 attorneys appointed with a decision of majority clause. So if they can't all agree, then it's 2 out of 3 rules. Anyone who's over 16 can be named as an attorney as long as they're willing and capable of making healthcare decisions for you. But you can't name someone as an attorney who provides you with healthcare, residential, social, training, or support services for compensation. So again, deciding who will be named as attorney, who it makes sense to name based on the family dynamics, based on people in your life, is a value that lawyers can bring to the process. We have a lot of experience discussing with clients, they have 2 children, but they really only believe that one of those kids will pull the plug, so to speak, when the time comes, which is what the parent really wants to happen. So we have a lot of experience having those discussions about who it makes the most sense to name. A lot of clients feel, that they have an obligation to name all of the children, even if they think that some of the kids wouldn't follow their wishes. To me, if you're naming someone who won't follow your wishes, it sort of defeats the purpose of advanced care planning. Again, getting back to validity of the documents, a power of attorney for personal care has to be signed by the grantor in the presence of 2 witnesses. And there are certain rules as to who can be a witness. A witness can be anyone over the age of 18, except the attorney themselves or the attorney's spouse or partner, the grantor's spouse or partner, a child of the grantor, or a person who is under guardianship or who has a guardian of the person. So again, lawyers can ensure that the documents are properly prepared and properly signed and witnessed to make sure that they meet the requirements of your jurisdiction. Some jurisdictions might require that that one of the witnesses be a notary. So it's really important that you seek the proper legal advice to ensure that the document will actually be valid in your jurisdiction.
I just want to jump in about who you name as an attorney,
Of
whether
course.
for personal care or whether for your finances. Sometimes I'll have a client that says, I'll say, do you want your attorney to keep this document? And they'll say, well, I don't know if they're reliable enough to keep my document safe. And then I say, well, if this person isn't reliable enough to keep your document safe, how are you going to keep tabs on things when you're incapable and you're in a hospital bed and you can't keep tabs on them? You absolutely must appoint someone you absolutely trust to make all your decisions for you when you're incapable of making them yourselves, including keeping your document safe. So I just wanted to throw it out there. And it doesn't have to be a person that is your best friend or is your family member. It could be someone that you trust because you know them and they're a doctor, or you can appoint a professional at a trust company to be your power of attorney for your finances.
Yeah, thanks, Sandy. That's all exactly spot on. So what are the duties of an attorney for personal care? And again, the exact duties will vary province to province. These are the legislative duties in Ontario, but there are similarities across the provinces. So the attorney has a duty to act diligently and in good faith, a duty to make decisions in accordance with the grantor's last known wishes that are applicable to the circumstances, if those wishes are known, or if no wish was expressed in the grantor, to make the decision in the grantor's best interest. And this relates back to one of the functions of the lawyer in the process, which is to, document your wishes. So very often power of attorney for personal care document sets out, the grantor's wishes with respect to withholding or withdrawing life-sustaining treatments, or it sets out the grantor's wishes with respect to, wanting to stay in their home. And those are the wishes at the time that the power of attorney is signed, but those wishes can change over time. And the grantor can always express, new wishes or different wishes to the attorney. And if the attorney has knowledge of those wishes, one of their duties is to act in accordance with them. So that's why it's always important to review and, update your power of attorney documents, over time, to pull them out of the drawer, read them over, see if they're still applicable, see if they still reflect your wishes. And, this gets back to what Sandy was talking about in terms of the life planning model. A 29-year-old who's preparing their first will and their first set of powers of attorney, their wishes with respect to personal care and advanced care planning are going to be very different from someone who's in their 70s and maybe has been diagnosed with an illness and still has capacity, but the circumstances that they're dealing with are very different at that time. So it's always important to update the documents, to update your wishes, but also to know that you may have a power of attorney for personal care that you signed 10 years ago, but if you are lying in the hospital bed and you still have capacity and you're talking to your power of attorney, you can give new wishes at that point in time without having to change the document. Those are your last known wishes, and the attorney has a duty to act in accordance with them. The attorney also has the duty to foster regular contact between the grantor and their supportive family members and friends. So it's important, when you're selecting your power of attorney, to keep these duties in mind. Continuing on with the duties, the attorney has a duty to consult with supportive family members and friends, and to consult with the persons from whom the incapable person receives personal care. The attorney has a duty to seek to foster the grantor's independence and to choose the least restrictive and intrusive course of action that is available and appropriate in the particular case. So when you're thinking about who to appoint as your substitute decision maker, the following the questions that are listed on the slide, are sort of prompt questions that you can you can ask yourself to determine if it's an appropriate person to name. Will this person serve your best interests when you're not able to speak for yourself? Does the person meet the legal requirements to be appointed in your jurisdiction? So, as I said, in Ontario, are they over the age of 16? Do they meet all the criteria to be appointed? Do you trust this person with your life, comfort, and well-being? Are you comfortable talking to this person about sensitive and difficult issues? Will this person understand your wishes and be willing to speak on your behalf? Can this person come to a decision that reflects your wishes, even when other family members have differing opinions? And again, what a lawyer can bring to the process in preparing the advanced care planning document is talking through these questions with you to help ensure that you're naming the appropriate person. So what are the implications if you don't have a substitute decision maker named? It's, first of all, it's simple and in most cases inexpensive to appoint a substitute decision maker. Obviously, lawyers all charge different fees. Some charge flat fees, some work on an hourly rate basis, but generally, just to prepare a power of attorney for personal care, it's not that complex or expensive a document to prepare. But that being said, many provinces provide free templates. In Ontario, the Ministry of the Attorney General has a free power of attorney for personal care template that can be printed, filled in, and as long as it's signed and witnessed in accordance with the rules in the Substitute Decisions Act, then it's a power of attorney for personal care. As I mentioned earlier, if a substitute decision maker is not named, so if you don't have a power of attorney for personal care, then other persons may have the power to make certain decisions under your provincial legislation. So in Ontario, the Healthcare Consent Act and that hierarchy of decision makers that I mentioned earlier. And if the particular decision that needs to be made isn't provided for under provincial legislation, or if there's a dispute over who will make the decision for you, then in most provinces, a court-appointed guardian of the person, or it might be called a committee of the person, will be required. And a court application is very costly, very time-consuming, and it can really be very divisive and lead to a lot of acrimony within a family. So, the alternative is kind of a $300 or $400 power of attorney for personal care, or maybe even a free one if you follow the free templates that the Attorney General provides, or a multiple $1,000 guardianship application. So, the other thing I tell clients is that the power of attorney can always be changed as long as you have capacity, right? So it's better. We don't want to let perfect be the enemy of the good. And, you can prepare a power of attorney now that reflects how things are now, what you would want if you got hit by a bus today and weren't capable. And it can always be changed in the future as circumstances change. But it is important to have the document in place, and it's important to involve your lawyer in the process and hopefully raise that 20% figure that we saw from the poll at the beginning. So that's all that I was hoping to talk about today, and I'll pass it back to Karen.
That's great. Thank you so much, Daniel. And it definitely generated some questions, so that's wonderful. I do want to mention that there are regional summaries for every province and territory in the back of the Living Well, Planning Well resource. So even though a lot of the information presented here was Ontario specific, to give you a sense of what it is, the back of that document has a breakdown, a 2-page breakdown for every province and territory in case you're wondering what that reality looks like in your jurisdiction. So I'm just going to go from the top to the bottom for these questions because that's the order that they came in. And I'll pose it to either Sandy or Daniel because I know, Sandy, you've got experience in this as well. But do you know, and one is in Ontario, one's in BC. This is a perfect question for our panelists. Do you know if you have a will prepared in Ontario and then moved to BC, would those documents still be valid?
So I can answer this because I'm a practicing lawyer in BC as well. If your will made anywhere in the world meets the requirements of a will in BC, which is that it is witnessed by 2 people at the same time who witness you signing the will and each other signing as witnesses. That's the tricky part. That's the part where everyone makes a mistake is, you know, they write their own will and they go across the street to their neighbor and they get it signed and then they go to the other neighbor and get it signed. That's actually not a valid will. The 2 witnesses have to be in the same room together, witnessing you and each other. Then it should be fine. And you're going to probate that will if you're in BC and you're domiciled in BC and you're living here and you've died in BC. And if you happen to have some assets somewhere else in the world or in another province, you may have to get that will resealed in another province, but it should be valid.
Yeah, and I would just add on to that you know, if you have sort of permanently made a move to a new jurisdiction and you have a will from where you used to live, it's prudent to get a new will prepared where you are now domiciled, because it will, you know, the lawyer will ensure that it meets all the requirements of that jurisdiction. They can talk to you about, you know, different planning opportunities that might be particular to that jurisdiction. So it is just a prudent thing to do.
That's a really, really good point. We get a lot of Albertans moving to BC, and BC law is very different from Alberta. We have a lot of litigation when it comes to estates because our laws are different. We have a probate fee in BC similar to Ontario. Alberta doesn't have it, so people don't do probate planning as they would in BC. So when you move to another jurisdiction, there may be some laws that you're not even aware of that could affect your estates quite significantly.
Perfect. Thank you both very much. The next one, I think you touched on a little bit, Daniel, but it speaks about, I think, the consent. So the question is, why do lawyers ask if someone would like to specify no heroic measures if in fact that can't be specified, like at the time of making the decision, that's going to be up to the substitute decision maker. So why would a lawyer ask it? I'm summarizing the present.
Yeah, again, it's about documenting your wishes, right? Because the attorney for personal care has the duty to act in accordance with the person's last known wishes. So if your wish is that, you know, if the doctors say that you have a terminal illness and you can't, you know, you can only, they can't, you'll never recover, and that you don't want heroic measures to be taken, that you prefer to pass away sort of peacefully. You're documenting that wish at that particular time in the event that you don't make a later wish. So it's providing guidance to the attorneys for what your wishes are. But again, those wishes can always be changed. So you may be, as I said, you know, in the hospital and still have capacity and about to, you know, go in for surgery, and you tell your attorney for personal care, you know, if I come out of the surgery and don't have capacity any longer, these are my wishes now. Those will, the attorney has the duty to follow those last known wishes.
So I think what I'm hearing is that really the documentation is one thing. The discussion with the person you're naming as your substitute decision maker is really, really critical, because ultimately when you are incapacitated, they will make that decision.
Absolutely.
Based on hopefully what you've told them. Perfect. Can you appoint your lawyer as your power of attorney for personal care?
I think legally you can. I would venture to say that unless the lawyer has a, you know, sort of a long-standing personal relationship with that client that sort of transcends just lawyer-client, you know, the lawyer may not be comfortable taking that on, and it may not be, you know, they may not be the person best suited to take that on. So I don't think that there's anything that legally prevents it. But, you know, it just has to be something that the lawyer agrees to, and that's appropriate in the circumstances.
Great. Sorry, I'm going rapid fire here because we've got about 5 minutes left and 3 more questions. For the attorney for personal care, can it be a healthcare professional if the healthcare professional, nurse, social worker, physiotherapist, is not directly involved in the care?
I'm
Sandy, I
happy to
see you
answer
shaking your
that.
hand.
Yeah, go ahead, Sandy.
I've spoken to nurses in British Columbia who are who work with a lot of people who have appointed someone as their substitute decision maker. One person gave me the example of a family member who was in another province but was a medical professional, I believe a doctor. And the nurses and the medical staff in British Columbia were completely comfortable with talking to her substitute decision maker on the phone. So the person was a family member or a friend, they had expertise, they were appointed, and they weren't even in the same province. So that might help some people know that your substitute decision maker can continue to communicate with your medical team and they don't have to be right by your side.
Yep.
Perfect. Thank you. What happens when the POAPC acronym is throwing me off, is in question? Like it is presumed it was completed with someone that wasn't actually capable to complete it.
So, right. So if the power of attorney document is disputed, then that would generally give rise to litigation. So, the person disputing the power of attorney would seek advice from generally a litigation lawyer and would either commence an application or take some form of step to challenge the validity of that power of attorney and to seek to have it set aside or overturned.
Perfect, thank you. And I appreciate this final question because it is something we talk about a lot in the advanced care planning space. There is a stress on documenting, but isn't it more important to stress communicating since ACP wishes do not need to be documented? So I'd love both of your thoughts on this final question.
So this is true because sometimes I have clients who don't want to pay for a representation agreement for healthcare. And in British Columbia, just like in other provinces, there's a checklist of people that the nurses and doctors will talk to first. So if you're married, to your spouse. If you're not married but have children, they go to your children. And so there's already a default of who they're going to talk to if you don't have a document in place. And the majority of people don't have a document in place. So communicating to your children, your loved one, your spouse, your partner, your friends, because your friends are on that list, is the most important thing. I mean, lawyers love documentation because it's like proof that this is the person. But in reality, most people don't have it documented. So you can even write a letter about your wishes and put it on your fridge, and say, if something happens to me, call this person. It could be as simple as that. So, if you don't want to spend a lot of money or don't have a lot of money to spend, just making sure that you communicate to the world who they should talk to, the medical team, and what your wishes are in some form so that they meet your needs is probably the most important thing.
Yeah, I completely agree with Sandy. And, I'll just add that as a lawyer who prepares power of attorney for personal care documents, I have standard or template healthcare directive clauses that deal with things like no heroic measures or DNR, things like that. But, I'm a lawyer, I'm not a healthcare professional, I'm not a doctor. And that clause, is very broadly worded. So going beyond the written wishes and communicating your precise wishes with respect to treatment, with respect to where you want to live, with respect to withholding care, palliative care is absolutely critical. I won't discount the importance of having the power of attorney document. It's important, but I completely agree with the person who posed that question, that communicating wishes, speaking with the substitute decision maker that you've named, speaking with your loved ones, going beyond just the written word is critical.
I want to also say that the 2 free resources on the advanced Care Planning Canada website, Living Well, Planning Well. There's a toolkit for the public, which we've mentioned, and a toolkit for the lawyers. I really stress that everyone download both for free, because the toolkit for the lawyers is actually quite informative. And a lot of lawyers actually don't talk about advanced care planning in any sort of detailed way. So you can help educate your lawyer as well.
Great tip. Perfect. So with that, we just hit 5 o'clock. I know a few of us have a hard stop right now. Thank you so much to our presenters. Thank you for everyone who took the time to join us here today. This will be available as a recording if you want to go back and go, what was that thing they talked about? Give us maybe a week to get it posted on the website, but you will get a follow-up email. So thank you again, Sandy and Daniel, and to Michael and Kate behind the scenes for just keeping it all moving. And again, thanks everybody for joining us today.
Thank you.
Thank you.
Bye-bye.
Bye.